I'm going to turn the program over to Robert Kitchenoff, who is COSAL's current president, who's been doing a fabulous job of heading up this organization in a very difficult time. Bill said it very well that, you know, most of these gatherings that COSAL would be done in person. That's a lot easier to manage. So we've been forced to go virtual, and Rob has been with us and heading this up every step of the way and doing a great job. So Rob from Weinstein, Kitchenoff, and Asher in Philadelphia, Pennsylvania, I'm going to turn the rest of the program over to you.
Great. Thank you so much, Pam. And thanks for your kind words. It has been a challenging but a very interesting time, and we've done a number of wonderful COSAL programs, this one included. First, I want to thank our sponsor, RG2, and Bill Wickersham, and I want to thank all of you for joining us today. We are honored to be joined by two of the premier Supreme Court practitioners, Tom Goldstein, the founding shareholder of Goldstein and Russell PC, and Deepak Gupta, the founding principal of Gupta Wessler PLLC. Tom is one of the most experienced Supreme Court practitioners, having served as counsel to a party in more than 125 merit cases at the court. He has represented a spectrum of litigants before the court, including both plaintiffs and defendants, in a variety of civil and criminal matters, including bond purchasers, with which I'm personally familiar, corporate defendants, debtors, employees, habeas petitioners, immigrants, investors, local governments, Navy veterans, and persons with disabilities. Only 3 lawyers in the court's modern history have argued more cases in private practice than has Tom. He has been counsel on more successful petitions for cert over the past decade than any other lawyer in private practice. In addition to practicing law, Tom has taught Supreme Court litigation at Harvard Law School since 2004, and previously taught the same subject at Stanford Law School for nearly a decade. Tom is also the publisher of SCOTUS Blog, a website devoted to comprehensive coverage of the court. SCOTUS Blog is the only weblog ever to receive a Peabody Award, which honors the most powerful, enlightening, and invigorating work in television, radio, and online media. Deepak focuses his practice on the Supreme Court, sorry about that, appellate and complex litigation with an emphasis on consumers and workers' rights, class actions, and constitutional law. This is one of the fun moments of being on a Zoom call. Okay. The rest of the world keeps chiming in. Deepak is a lecturer at Harvard Law School, where he also recently was a Wasserstein Public Interest Fellow. Before founding his firm in 2012, Deepak served as senior litigation counsel and senior counsel for enforcement strategy at the Consumer Financial Protection Bureau. As the first appellate litigator hired under Elizabeth Warren's leadership, Deepak was instrumental in launching the Bureau's amicus program, defending its regulations, and working with the Solicitor General's office on Supreme Court matters. For 7 years before that, Deepak was an attorney at Public Citizens Litigation Group, where he founded and directed the Consumer Justice Project and was the Alan Morrison Supreme Court Project Fellow. Deepak has argued before the US Supreme Court multiple times and has handled appeals in every federal court and 7 state Supreme Courts. In November 2018, he was appointed by the Supreme Court to brief and argue in support of a judgment left undefended by the Solicitor General. He has also testified before the US Senate and the US House of Representatives, and frequently appears in the national media to discuss legal issues. We're honored to have the two of you speak to us today, and if anyone has questions for either Deepak or Tom or both of them, you can use the chat function, and I will get your questions to the panelists. Deepak, take it away.
Great. Well, thanks, Robert and Pam, for having us here today. I'm so sorry we can't join you in person. I'm a big fan of COSAL and this organization. And I also am really glad you all got a chance to hear from Nan about the Building the Bench project. It's a project I've been trying to help with. And I really do hope you follow up on her suggestion and give her the names of practitioners that you know that you would love to see on the federal bench, because that project is really only as good as the suggestions that come from people like you. And I gotta say, I'm particularly pleased to be doing this this panel with Tom. I first met Tom when I was at Public Citizen, and his firm and the amazing practice that he's built has really been an inspiration to me in building my own firm. You know, I know that you know, you are antitrust and class action lawyers, and Tom and I were discussing what we would talk with you about, and unfortunately, the pickings are kind of slim when it comes to the past term and the upcoming term. The court doesn't have antitrust cases on its docket, and last term, although it was a pretty big term, the court did not do a whole lot in either space. And so I thought one thing we could do is first, I might just take a little bit of a step back and go back 1 or 2 terms and talk about some of the things we've seen in antitrust cases from this court. And then, and Tom is gonna jump in as I chat, and I'll do the same. I'll try to do the same so we keep this as interactive, or somewhat approximating as interactive as it might be if we were in person. And then we'll give you a preview of some cases, including some cases we're involved in. You know, I think if you had surveyed the folks on this webinar and asked them if they thought that when Justice Kavanaugh joined the court, that you were likely to see a 5-4 opinion where Justice Kavanaugh would join with the liberals in upholding antitrust plaintiffs' ability to bring a claim over the dissent or objections of all of the conservative justices, I don't think many of you would have said that. And I probably wouldn't have predicted that either when we were looking at Justice Kavanaugh's opinions from the DC Circuit when he was nominated. I think many people focused on some citations in a DC Circuit opinion of his to Robert Bork's writings on antitrust law, and people thought, well, he's a foot soldier in the conservative legal movement and is going to have a blinkered view of competition claims. And yet, you had this decision in Apple versus Pepper, in which Justice Kavanaugh wrote the majority opinion joined by the liberal justices, and the lead dissent was written by Justice Gorsuch. And so you had 2 Trump appointees parting ways in a really important antitrust case. And you know, I went back and looked at that Justice Kavanaugh's opinion in preparation for today, and was really struck by the way that the opinion champions the need for effective private enforcement of the antitrust laws. In rejecting Apple's Illinois brick defense in that case, Justice Kavanaugh said that barring iPhone users from suing Apple over purchases that they make on the App Store would, in his words, directly contradict the long-standing goal of effective private enforcement and consumer protection in antitrust cases. I don't think that is the stereotype or image that many of us may have had of Justice Kavanaugh. Now, this does not mean that he is not a conservative. He certainly is, but it means that there is an openness to antitrust claims, and particularly the need for consumers to be able to enforce antitrust claims. And while the court did not go as far as many asked it to do, it didn't overrule Illinois brick. The decision indicates, I think, an openness to reconsidering Illinois brick and its foundations, and indicates a more practical and realistic approach of the economic realities of a situation in which, while the consumers might not be paying the commission, they are ultimately the ones harmed and have the right to seek a remedy. And it's worth just contrasting the decision in Apple versus Pepper from a decision another 5-4 decision that was decided just a year earlier in the Ohio versus American Express case there. And you kind of have a similar situation there. It was a 5-4 decision. You could, Justice Kennedy joined the conservatives in the majority. But the problem there is also a question of whether or not it matters that the harm is really going to be passed through to consumers. And recall there that the court said that that wasn't sufficient, that the plaintiffs had to prove not just that there would be a harm to merchants, but also that the harm would be passed through to consumers. And because in the court's view, the plaintiffs had failed to prove that, they did not have a viable antitrust claim under the rule of reason. I think one thing to watch for in the coming terms is whether or not Justice Kavanaugh really is staking out a pro-enforcement position in this space. And Tom is going to talk about some cert petitions that are percolating up, one of which I think includes an Illinois BRIC issue. So that'll be interesting to watch. In terms of and Tom, I don't know if you want to say anything before I turn to the cases for the coming term.
No, absolutely.
Did you want to say anything?
No.
Oh, okay, go ahead. Yeah. So when Tom goes through the petitions, we can chat about that case. But as I said, when you look back at last term, although it was a blockbuster term, we had a really important decision on gay rights and transgender rights. We had some very high-profile cases with a political valence. We didn't have much in the realm of competition law or private enforcement through the class device. The really big case in the consumer protection economic justice space, I think if you had to identify one, was the SELA law case, in which the Supreme Court struck down as unconstitutional the structure of the Consumer Financial Protection Bureau. It was a personally very disappointing result to me as someone who helped form that agency, but it remains to be seen how much practical on-the-ground impact it will have. It's not going to, I think, hamstring the ability of the agency to do its work going forward. So turning to next term, there are at least two cases I want to flag before turning things over to Tom. And the first one is a case that I'm going to be arguing in October, and actually the same day that Tom has an argument. I'm going to be arguing a pair of personal jurisdiction cases that are from Montana and Minnesota, in which I'm representing auto accident victims that are suing Ford Motor Company. And I think this is an important access to justice case that I think is worth paying attention to. And it implicates some of the really tough, unsettled issues. If you think back to law school, you think back to the stream of commerce cases, which the court has never really grappled with. To what degree can a foreign manufacturer or a company that puts items into the stream of commerce, to what degree can they be held accountable in the forum in which the plaintiff may have felt the injury? Now, I don't think that these cases are technically forum cases. These are really garden variety cases. The fact pattern in the two cases is remarkably similar. In each case, somebody gets a car used in the state in which they live, and they get into an accident in that state involving other folks who live in that state. And they allege that something about the Ford vehicle caused the injury. In one of the cases, the Montana case, it's a rollover involving a Ford Explorer. In the Minnesota case, it's another kind of defect. And in both cases, there's very serious injury. And you would assume, I think most of us would have assumed, that since everything about the case has to do with the forum state, the plaintiff lives there, the accident happened there, all of the witnesses are there, And of course, Ford extensively sells these particular vehicles in the state, that this wouldn't be a tough personal jurisdiction issue. And perhaps 30 years ago, that would be true. But the argument that Ford is making is a pretty simple one. What they're saying is, look, in order for there to be minimum contacts in the jurisdiction, we have to have done something in the jurisdiction. We have to have, there has to be some action that we took in the forum state that caused the injury about which you're complaining. And you can't point to anything because we didn't design the car in the forum state, we designed it in Michigan. We didn't manufacture it in the forum state, we manufactured it in our factory, one of which is in Kentucky, the other is in Ontario. And we didn't even sell this car to the first consumer in the state. We sold it in another state and it was purchased used by your plaintiff in the forum. And so there isn't any contact that we have that's causally connected to your claim. And the court has never really been very clear about precisely what relationship is required between the contacts with the state and the claim. One way of thinking about the question that the court has to decide is how specific does specific jurisdiction have to be? We say that the court has never insisted on a strictly causal test, and it would be exceedingly difficult to administer a test like that. You don't even know in many cases where the part, which part caused the problem, where that part might have come from. How do you trace things through the stream of commerce to make that kind of causal showing? It would be exceedingly difficult. Causation is notoriously difficult, and it would be one of the hardest issues in the case in chief. And so to require that kind of proof at the outset is going to be very, very difficult to administer, and would really be a sea change in the way these kind of garden variety cases work on the ground today. But the court has, at the same time that it has narrowed general jurisdiction, it's also narrowed specific jurisdiction. And Tom argued the most recent case presenting this issue, case called Bristol-Myers Squibb, was a mass action case in which the court narrowed specific jurisdiction. And Ford says that there's a direct line between the case that Tom argued and the case that I'm going to argue, that in both cases, the plaintiffs cannot show the requisite causal relationship between the defendant's contacts with the forum, even though everyone admits that they sell the product in the forum and they indeed have extensive contacts with the forum. They can't show that connection between the contacts and the claim. And so it'll be interesting, to see what the court does with. I think from our perspective, we have about the best fact pattern as you could imagine to tee up this issue, because it is such a ubiquitous fact pattern, and it is one in which the equities so strongly seem to favor the injured person who is, if you think about it from their perspective, they're injured where they live. Everything about the case happens there. Basically, they are, if you remember your first year law school personal jurisdiction cases, they're sort of like Volkswagen in the Volkswagen case. And Volkswagen never argued that there was no personal jurisdiction over the car company, because I think that back then everyone assumed that there would be. So there are some strong there's strong administrability concerns on our side. I think if you just think about it in terms of the equities and fairness, we have a strong case. And I think there are also some very strong state sovereignty interests on our side. 40 attorney generals filed on our side of the case, including very conservative states like the state of Texas, arguing that this would really deprive the states of their ability as sovereigns to provide a forum for their own injured residents. So I'll stop there because I'm way more curious about what Tom has to say about this case than what I have to say about it.
Well, it's a pleasure to get to be here with everybody to talk about these issues. I have to say that I think that the personal jurisdiction cases that the court has been ruling on over the past 10 years have gotten insufficient attention. And the rise of formalism over pragmatism has been really, really striking. And the breadth of the Supreme Court majorities for narrowing not just general jurisdiction, but specific jurisdiction, as Deepak is saying, has been startling to me. It may have something to do with the general sense in which Justice Ginsburg has been surprisingly formalist about this, and that other members of the court on the left have followed her lead. But it's really been only Justice Sotomayor who has been like, wait a second, the inquiry here is whether it's fundamentally unfair to sue this massive multinational corporation that does billions of dollars of business in this state. And how in the world could you say that it is? And it has, these decisions have enormously broad implications, both for cases like our Bristol-Myers case, which is a mass action, and so, the ability to aggregate claims, but also what I had, as Deepak suggests, ever since law school, has understood to be just kind of the ordinary, obvious scenario in which you could sue a big company for putting something in the stream of commerce, knowing that it would end up, there was a prospect it would end up in any of these states. But so far, at least, and our firm has managed to litigate and lose all of these cases, I believe. And so you understate the significance of our role in the destruction of personal jurisdiction jurisprudence in a way that's I'm grateful for. Because it has both in both the general and specific jurisdiction contexts, it's been startling. And obviously, if you can keep somebody out of court, it's a form of tort reform on its own. And there does seem to be, very strong momentum on the right and even some momentum on the left to use personal jurisdiction as a door closing mechanism to the federal courts, in a context that I would not have thought really were triggering as worrisome or suggested that they were manipulative. I was quite surprised that the court was willing and interested in already stepping into this. I remain very hopeful that with Deepak's advocacy for the plaintiffs, we'll finally, pump the brakes on the move on restricting jurisdiction as a constitutional matter. But I think the cases could not be more important, because if the plaintiffs can't win jurisdiction on these facts, it's a deeply, deeply troubling thing, because Deepak has such clean cases up there.
Yeah, I mean, I have to think that the facts, have to matter, have to be driving this analysis to some degree. And I think in BMS, I mean, you did a terrific job of reframing the case compared to the way it looked in the lower courts. But I do think there was a perception, perhaps, at the court, that these were plaintiffs who were, forum shopping. They're trying to, come to California because it's a favorable forum, and there's a disconnect to some degree with maybe what the court might think of as the center of gravity of the particular individual's controversy and the place where they're suing. And you just can't say that about these Ford cases. And so I hope that makes a difference. But you're right that the decisions have been tremendously formalist, and there is a kind of very simple, appealing formalist logic on the other side. I have to grant them that. It's just, this is kind of the logical endpoint of where that leads, and it's a really untenable result. I think if you had to explain these cases to people who are non-lawyers, who didn't know anything about what personal jurisdiction was, and you explained that this was the result that the Chamber of Commerce is advocating, they would think it was truly bizarre. And so,
right. And just to give everybody just a touch more context for what Deepak is saying about the difference between the Bristol-Myers case and this one. So in Bristol-Myers, it was uncontested that California plaintiffs who bought this drug in California could sue in California. That case was also an attempt to bring claims in the same action on behalf of Kansas plaintiffs under Kansas law. And so while the logic while the reasoning of the opinion is formalist, there is a pragmatic sense that Deepak has stepped into of saying like, well, maybe, and hopefully what was driving the court then was that it was apparent that the plaintiff's lawyers in that case thought that a California trial judge would be a much better judge for their case than a Kansas one. And then if you could put all the plaintiffs together from all of the cases, you could create enormous settlement pressure on Bristol Myers, things like that. And those kinds of drivers are completely absent in this one-on-one case in which all of the operative facts relating to the accident occur in the forum state.
Right, right. And so hopefully we can put BMS in the box of mass action forum shopping, and we'll see very soon whether or not you can extrapolate from that to broader approaches to jurisdiction. But the court has sort of had a tendency, and I think that that's what they did in your case, of taking off ramps, of not really deciding the big questions and allowing these questions to kind of linger. And I have to hope that they took the cases not to radically change the law, but simply to try to provide some clarity in an area where, admittedly, there isn't a lot of clarity.
Yeah, it is a little surprising that here we are in 2020 and this kind of foundational fact pattern remains unresolved, even if we didn't think it remained unresolved.
Yeah, no, it's really pretty remarkable. So maybe the court just wants to do its job and help the lower courts. And I think that would provide a lot of clarity in a whole range of issues. And this is something if you do the kind of work that all the folks on this webinar do, these are really important issues, especially when you're dealing with foreign corporations that you're trying to sue. So that's one case I wanted to flag. Another case I wanted to flag is really kind of just not related at all to the work that you all do, but I thought you would find it interesting. And it is a big case that you'll be hearing about. And this is a case called Catholic Social Services versus Philadelphia. And I am among the counsel for the city of Philadelphia. The case involves the clash between anti-discrimination norms on the one hand and First Amendment protections for religious liberty on the other hand. And this is a big issue that the court dealt with earlier in the Masterpiece Cake Shop case, the case about the baker who was asked to and objected to making a cake for a gay couple for their wedding. And as you'll recall, perhaps when Justice Kennedy was still on the court, the Supreme Court largely ducked the big questions in that case and left them for another day. And so court watchers have been wondering how far the court would go in the name of religious liberty and cutting back on protections for anti-discrimination, particularly with respect to sexual orientation. So the facts of this case are that the city of Philadelphia has a foster care program, and it works with various agencies, secular and religious, to evaluate families for foster care and to place children in homes, and has been doing so with the Catholic Social Services, which is an arm of the Catholic Church, without incident for a long time. They've had a perfectly harmonious relationship. But the city of Philadelphia does have a non-discrimination policy. It prohibits discrimination on the basis of race and also of other protected characteristics, including sexual orientation. And the church maintains that it should be able to perform this function and not work with same-sex married couples, given the church's position on same-sex marriage. Now, this is an odd case for the court to have taken because it combines the very difficult issues about the clash between free exercise clause rights under the First Amendment and anti-discrimination. It combines that already very difficult set of issues and with the context of government contracting. Because remember, they're in a contract with the city of Philadelphia. They're taking government money. And so they are asserting, in effect, a right to take money from the government to perform a governmental function that they don't have a right to perform. The city selects its contractors, and then to do so in a discriminatory manner in violation of the city's rules on contracting. And the question presented in this case includes the question of whether or not the Supreme Court should overrule its decision, its seminal decision in this area, in Employment Division versus Smith, which requires, which holds that as long as there's a generally applicable rule, that it doesn't violate the free exercise clause. So, if the government does something like prohibit a drug, and you need that drug because it's important to you for your religion, too bad, as long as the government isn't singling you out for your religion. That has been the law so far, and there's a movement afoot to overrule that decision and to be more protective of free exercise clause rights. But this is an extremely strange case to take that issue up in, because the government has a special role to play in deciding what conditions it can place on government funds. And so, I think I'm biased here because I have a dog in this fight. I'd be curious what Tom thinks, but I think probably most of the people who are watching the court think that the court will find its way to 5 votes on the challenger's favor. But precisely how they will do that, given the government contracting scenario, is difficult to envision.
I do think this is one of the interesting situations where, you feel at different times the loss of particular justices. And here we have the loss of Justice Scalia, who simultaneously was an advocate for and driver behind Smith, and also was a member of the court who felt most strongly about the government's power to do whatever it wanted when it was contracting. And so it's a good illustration, of course, of how the court, the conservatives aren't all, alike, and the more progressive members of the court aren't all alike. It does have the shape and feel, the circumstance of kind of, we have some things that we want to do, and we're going to find a case in which to do them. Mm-hmm. I also think that the court has been, looking for a balance. You see the plaintiff prevail in the Title VII cases. The plaintiffs prevail last term on discrimination on the basis of sexual orientations and gender identity. And at the same time, all the way toward, back towards Justice Kennedy's seminal decisions on gay rights, the court has been trying to signal that it doesn't think that people who are opposed to those family arrangements are, inherently bigots. And so it has been, searching around for the path to take in order to somehow articulate and advance both principles. And the other thing, the cross current here, is that the conservative court really, one thing it has not done is gone very far in the transformation of its religious liberty jurisprudence. It's something that remains very much, I think, on the conservative agenda at the court. And so when you get cases involving religious liberty, you tend to get, I think, an extra push from the conservatives because they're trying to make very sweeping doctrinal changes in this area to lower the wall separating church and state in a way that, there is a decent amount of legacy Warren Court, early Rehnquist Court jurisprudence still stuck around here that hasn't been overruled and carved back on in the same way that we've seen in other areas. So it is really interesting. Deepak, as a Supreme Court litigator, me as someone who watches the court a lot, cases just sometimes have a feel of kind of like excuses, and you look at the case and you're like, I don't see how it is that I'm supposed to lose this case, and yet you know that you are swimming against much broader
Yeah.
tides and currents, and no matter what the underlying logic is, you just have the feel that there's going to be some opinion that comes out that just like molds your case into something in which they can accomplish something. It does seem like the city, it seems very strange to say that the city, in trying to administer this program of its own and wanting to make sure that the people who it works with aren't engaging in, something that it regards as invidious discrimination, and which it reasonably can regard as discriminatory,
Right.
is thereby violating the Constitution. But one also has the feel from the cert grant and from the direction of the case law that the Supreme Court is headed in the direction of a much more of a policy of like, you cannot pick out an organization on the basis of something that is the expression of its sincere religious views. You just can't do it, programmatically in the government, no matter what, whether you're offering aid, which is the kind of cases that we've seen so far when it comes to, a playground program, or whether you're like deciding who gets a tax write-off or whatever, or now administering, an adoption program or whatever. So, but it is one of these cases. The two cases that Deepak is doing are just foundational. I mean, how it is that you're going to have access to the courts and how the government will interact with religious organizations are just like so much is built off of those principles that they are extremely important cases.
And that's not the only really. Actually, I think conventional wisdom would be that the case that will probably get the most attention so far of the cases that's been granted is the case I think you're planning to talk about, right? This healthcare case.
Yeah. So I thought I would mention one case in the upcoming term, and then 6 pending cert petitions. The upcoming case is of general interest, and the cert petitions are potential interest to members of this group in particular. The merits case for next term is the Affordable Care Act case, California versus Texas, or it has a bunch of different names because there are multiple different cases, but that's basically it. Blue states versus red states and the Affordable Care Act. This reaches back to the first Affordable Care Act decision, where everybody will remember that Obamacare has a mandate to purchase health insurance that was sustained somewhat surprisingly on the ground that it was a tax, because Congress said, if you don't get a minimum amount of coverage, and this is called the minimum coverage provision, then you're going to have to pay a tax. After the Supreme Court 5-4 upheld that provision on that basis, and remember, it's foundational to Obamacare, or was at least as the program was getting set up, because we needed to bring healthy people into the insurance pool. And if you had an insurance pool that was made up of entirely sick people, then you couldn't balance out your insurance, how much money the insurance companies were bringing in, because if everybody was sick, then there was going to be an enormous amount paid out for care. So after the Supreme Court's decision, Congress got rid of that penalty and reduced the tax on people who do not get a minimum amount of insurance care to 0. So various conservative organizations and states sued, alleging that the minimum care provision was therefore unconstitutional, and in turn, the whole statute was unconstitutional, because that was kind of at the very, very root of Obamacare, and if you didn't have that, Congress would not intend to have the statute at all. And Obamacare is the world's most complicated statute. I mean, it has hundreds of substantive provisions, and the theory of the case is that the unconstitutionality of the minimum care provision blows up the whole thing. The Trump administration has joined in the effort to blow up the statute. The president does say that he favors, for example, protections for pre-existing conditions in insurance, and wants for there to be incredible health coverage for everyone. His mechanism for doing that remains a closely guarded nuclear secret because his lawyers are only trying to blow up the statute. The Supreme Court has taken up a few different interrelated questions. One is the threshold question of, is the fact that the tax is gone a basis for declaring the minimum coverage provision unconstitutional? That is a highly technical question that has very little practical consequence, because everybody agrees that at least the minimum care provision has no substantive force to it, because if you just as an individual decide to ignore it, nothing happens to you. So whether it's unconstitutional or instead inoperative doesn't make a big difference. What does make a big difference is what follows if it is unconstitutional. What happens to the rest of the statute? The Fifth Circuit in this case had vacated and remanded a district judge's decision that the entire statute was unconstitutional for further consideration, and the Supreme Court jumped essentially over that and agreed to decide the implications of the severability question. The conventional wisdom here is that Congress has made perfectly clear that it believes that the rest of the statute can and should remain in place, hence the fact that it withdrew only the penalty, not the entire statute, for example. The Trump administration nonetheless has strongly advocated the conservative position that almost the entire statute is blown up. There are some particularly politically and economically important provisions that it says survive for reasons that are a little unclear. But I think that the better view is that the Supreme Court will say that the minimum coverage provision is unconstitutional, but the rest of the statute remains and is sustainable on other grounds. But it is an interesting case because it will be argued right around the time of the election, and healthcare obviously being a significant issue to Americans. It will get a decent amount of attention. If the court had really used its first in, first out basis for assigning cases for oral argument, it would have been argued the day before the election, but they did manage to put it to the week after the election. I don't know if that was purposeful or not, but it won't get as much attention as a result, but obviously a very important case. So let me, unless Deepak wants to say something about the Affordable Care Act, I'll turn to some upcoming cert petitions.
Yeah, no, I mean, I think I agree with your analysis, and I think the conventional wisdom is, that the result will be as you predicted. I just think it's worth flagging for folks how deeply cynical the argument is. The idea that the Congress that enacted this statute would have wanted the entire thing invalidated if this provision were missing. Nobody really thinks that, and so. It is disturbing to me that we have all of these states and the Solicitor General's office signing on to an argument of that kind.
Yeah. And the court did decide a couple of severability cases last term that really, really strongly reinforce, I think, the idea that the court is going to, looks to do the minimum amount of surgery on the statute that it can when it finds a provision to be invalid. And we would expect the same thing to happen here. So let me mention relatively quickly these 6 pending cert petitions that raise issues of interest to COSAL members, and then make sure that we leave a little bit of time for questions from the membership. Number 1 is a case called Sterling Jewelers, which is a legacy class-wide arbitration case. Comes out of the Second Circuit. The Second Circuit, the first time the case was there several years ago, had upheld an arbitrator's decision that because the arbitration provision in general terms broadly entitled the plaintiffs to all of the remedies that are available to them outside of arbitration, that was sufficient to authorize class-wide arbitration. And the Supreme Court has been asked to invalidate that decision and to strongly reinforce the somewhat unusual rule, what I regard as unusual, but pretty firmly established, that the Supreme Court is extremely favorably inclined to arbitration and hostile to class-wide arbitration. And, what deference does an arbitrator get in making the decision, in interpreting the agreement? And is the Supreme Court going to say, we don't even care that the agreement is within the arbitrator's zone of authority to interpret, unless there's an affirmative consent to class-wide arbitration, forget it. And that, that rule, which would not be shocking to see from this court, would just really be an illustration of how much the court has just involved itself in producing defendant favoring results when it comes to arbitration. It'll be interesting to see if they take the case. The second is a case called Kansas City Royals, and that's a class case that is a follow-on to the Supreme Court's recent Tyson Foods case that seemed to broadly approve the use of statistical evidence when the defendant in a wage and hour case has failed to maintain the records necessary for the plaintiffs to bring their claims. This is a cert petition by Paul Clement asking the court to carve back and place new limits on the use of kind of generalized statistical methods of proof. And it also, in general terms, presses aggressively the argument that the plaintiffs have to prove cohesiveness as a threshold to any class action. The third one is a case called Weatherly. It's an American pipe tolling case, and it asks the question of whether and to what extent American pipe tolling applies when it's a diversity action, therefore a state claim rather than a federal claim. Is the state tolling law apply in that circumstance, or does the federal American pipe rule apply? And if so, how does it apply? Because here the plaintiff is relying on the filing, it asks whether it applies to an action that was filed before the federal court decided class certification. American pipe tolling being an important rule for tolling statutes of limitations when there are parallel class action and individual actions. The fourth case is called Ninth Inning. It's a joint venture case, and it asks, it's a potentially important antitrust case. It asks, when you are looking at the competitive consequences of a joint venture, how much can one assume that there's an impairment of competition from the existence of the joint venture, and how much is a full and deep rule of reason analysis required there? This is a cert petition brought by the defendants, the Ninth Circuit having ruled for the plaintiffs. The fifth one is a securities case of mine called Goldman Sachs, and it's about rebutting the basic presumption in Halliburton. The Halliburton litigation at the Supreme Court, we had gotten the court to strongly reaffirm the basic presumption. This is a case about rebutting the basic presumption and how it is that you do that. The questions presented are written relatively broadly, and so who knows what the case would turn into if the court were to take it, but it's about the burdens of production and persuasion, and it also implicates the recognition of securities cases that are based on price maintenance, the idea that the defendants' statements about what they were doing kept the price of the stock up, and that you measure the fraud from how much the stock later declines when the truth is revealed. And the last case that I'll mention is called Walmart. It's brought by Walmart. It is a competition case in the sense that the Dormant Commerce Clause protects competition. Walmart having the state of Texas having a rule that says that corporations can't get liquor licenses, and that having the consequence that 98% of the license owners in the state are in-state, because the out-of-state entities are much more likely to be corporations rather than small, family, closely held entities. And so it's an invitation to the court to take a look at whether formalist distinctions there, the statute doesn't say anything about an in-state or out-of-state corporation, are controlling, or if instead you have to apply even when the statute is spatially neutral, as between in-state and out-of-state entities, you still have to take a more searching inquiry when the obvious consequence is to restrict out-of-state competition. Those are, who knows which of those cases, if any, the Supreme Court will take, but those are the six that I think are most likely to implicate the cases brought by COSAL members. Maybe we'll stop with our own kind of presentation of cases and then turn to questions from the group, if any. And the first one from David Weinstein is, how would you see current personal jurisdiction case, I think probably case law, applying in a case under state antitrust law? So I don't know if you want to talk about that, Deepak, given Ford.
Sure. Yeah. So, right. I mean, I think this is much more likely, the issues are much more likely to arise with respect to state antitrust cases than federal antitrust cases because you don't have nationwide service of process, right? And, I think whenever it's going to be very difficult in a lot of cases if there were a causal rule to trace actions that the defendant actually took in the forum to cause that claim, particularly if there's a chain of distribution. You're talking about a foreign company or even a domestic company where products are sold through a distributor or in the stream of commerce and are ending up in the state in which you're suing. A causal rule is going to make it much more difficult to bring those state antitrust cases. Now, I'm not saying that already the law is sometimes difficult in those cases if you have a distributor, but a causal rule would make it extremely difficult, I think. And then the question is, what is the causal standard? One thing that we don't know is whether the court, if it were to adopt a causal test, would actually say what that causal test is. And there's some debate about this in the Ford cases. Ford says that its test is a proximate cause standard, but doesn't really articulate precisely what that test would look like. So if we were to lose, there could be a lot of follow-on litigation about what the contours of that test are. I think if we prevail, the law would be as it is now, and you'd be able to show a set of relationships other than just a causal relationship. So, for example, the injury is felt there. The occurrence happened in the jurisdiction. Tom, I don't know if you have more you'd like to say about that.
No, the one thing I will say is that Deepak mentions in passing another really important issue, and that is, these federal nationwide service of process statutes. The position of the United States government, and kind of something that's broadly recognized, is that when you have a federal statute that says you can bring a case where the injury occurs or whatever, that's somehow different. But it is deeply under-theorized why that would be true. And so, one thing that's lurking in these cases is the question of whether, the federal government, in taking the aggressively pro-defendant, anti-jurisdictional positions that it has been, is seriously undermining, the antitrust and securities laws, for example, because the corporate defendants in the cases are always saying, oh, those are federal statutes, don't worry about that. That's a separate question. But as soon as they were to win a case like Ford, for example, they would surely turn around and start arguing that those nationwide service of process statutes are unconstitutional. And if formalism really does control here, it is hard to understand. The Supreme Court sometimes does just adopt arbitrary distinctions and that sort of thing, but I don't really understand why it is that the Constitution would allow you to bring a claim under a federal statute, but not when the identical claim under a state statute would be unconstitutional. It's hard to say.
And this came up when we met with the Solicitor General's office. There were folks from the antitrust division there, and I think they were concerned about what the implications would be for federal statutes and nationwide service of process. And the Solicitor General has one page of their brief that just the heading is, these cases raise no issues on limits of the jurisdiction of the federal courts, but there's very little in that section to be worth taking a look at. And so, yeah, I do think that's the next issue. Interestingly, one thing I should have mentioned about this case, it's, I think, the first case in a decade where the Supreme Court rejected the Solicitor General's request for oral argument. So they will not be hearing from the SG and will not be able to press them about that issue.
Right, it is really, so the SG files a brief that says, this has nothing to do with any federal interests, and the Supreme Court finally says to them, okay, fine, well then you don't need to be arguing in this case if you're serious about it.
Right.
But it does, on some level, I imagine, well, the defense, you always want the Solicitor General on your side because it has institutional prerogatives and the justices listen to them. I wonder if the defendants weren't happy to have them out of the case, thinking, well, at least there'll be no reminders that, the elephant in the corner is these hugely important federal statutes and how it is you're going to be able to bring lawsuits under
Right.
them.
Well, yeah, I think they probably would have preferred to have the SG there, and we would have preferred to have the state SG. You know,
Yeah.
we had Texas on our side, and I think maybe the court just said, this is too complicated. We can't have 4 advocates. It's a pandemic. We're doing this by phone, and so go
Right.
away.
Especially when the states and the SG aren't actually doing that much that's different.
Right.
Right. I mean, it's not like the SG was coming in saying, hey, we have some special theory and distinct theory of the case. The parties did seem to be mostly lined up with each other in terms of the substantive argument. So it was,
Yeah.
you know, understandable. But I think your point about the pandemic is probably a good one too. The court has a much easier time dividing 30 minutes evenly because they can do 3 minutes of questioning per justice and get to 27 minutes. At the point that you add in another advocate, it becomes very, that's when those arguments went over a lot last term. And so that's probably does have something to do with it.
Yeah.
I want to pose a couple of questions for you guys that are of some interest to our COSAL group. I'm wondering, first of all, I know that you presented a bunch, Tom, of the pending cert petitions, but the Kansas City one struck me particularly, and I'm wondering if you have some thought as to whether that has a likelihood of being taken by the court, and also how you see Justices Gorsuch and Kavanaugh playing out in class action and antitrust cases.
So, you know, with respect to whether I worked on that case some in the lower courts, and, you know, I thought that case was really, really, really easy. And that is, you know, you have a bunch of baseball players and they're saying that they're owed overtime. And I don't really understand why that you can't litigate that question out. These are the minor leaguers. It doesn't seem to me problematic at all to think that all of their claims would be adjudicated together. And if there are, you know, differences among them, you know, different state laws, well, then their substantive claims might be evaluated differently. But just the general question of, you know, whether they're owed overtime didn't seem to be something that was a crazy class action. It's a relatively small class action. The only thing that's interesting about it is that, you know, the minor leaguers played in, you know, Florida versus Texas versus Arizona. And that can add some level of complication, but I don't know. This is a case where they brought in Paul Clement, and Paul is very good at being able to draw attention to a case and draw interest to it. But I don't know. The court also does, when it decides something like Tyson Foods recently, it will tend to stay away from an area rather than pivoting back in the opposite direction quickly. So personally, I would be surprised, but Paul has been enormously successful. You know, in terms of where we see the new justices, our best example is, you know, probably our best, you know, substantive tool to figure them out is Deepak's discussion of Apple and Pepper. It's, you know, that there can be divisions between the two of Kavanaugh and Gorsuch on questions like this, but very hard to derive much from individual data points. In general, they're conservative justices, and I would not expect them, you know, I wouldn't expect Justice Kavanaugh's ruling in Apple to portend like you know, something that just is transformative, and he now gets to take the mask off and is a, you know, pro-plaintiff antitrust justice. So you know, there's an awful lot to be seen. I think it'll be extremely context dependent.
Yeah, I think that's right. And I definitely wouldn't, any of the comments I made, even about substantive antitrust law, I certainly wouldn't extend that to the procedural issues surrounding private enforcement or class actions, things like the ability to get a class certified, or the arbitration cases where I think, especially in the arbitration area, we've seen the same kind of 5-justice consistent majority, and I don't see any reason to expect that will change.
There's been, I think, much made of the cases that came out 7-2 this past term. Do you see anything developing there with that, or were those cases just sort of aberrations?
Well, I do think that you may see the center of the court working together a lot. That's in part because I think the more progressive justices, like a Justice Kagan, like a Justice Ginsburg, are being extremely tactical in trying to minimize the damage from a lot of decisions and willing to make some sacrifices, because the Chief Justice, I think, is very interested in not having a ton of just 5-4 ideologically divided cases. So yeah, I think you'll see more stuff like that, where, you know, Justice Alito and Justice Thomas are kind of out on a wing, and 7 other members of the court are able to come together, or even, you know, 5 in the center and the 2 wings left out. That's in part true because in general, despite areas of law like jurisdiction, there is a lot of pragmatism in the center of the court, and I think you could see that kind of thing take hold. You could see it in a case like Deepak's Ford case, where the center of the court comes to kind of some compromise that is, you know, very fact-bound and kind of limits the scope of personal jurisdiction in stream of commerce cases, but doesn't get rid of it. Whereas a Justice Sotomayor might be willing to be much more aggressive, and Alito and Thomas much more restrictive. But, you know, there's so many different bodies of law. One thing that you are seeing is that the court, when you do have retirements and you have a death of a Justice Scalia and stuff, it jumbles things up. And so it could take quite a while for it all to play out.
Not seeing other questions. Do either of you have anything further that you would like to add?
Nope. It's been great being with you all, and thanks so much for the opportunity.
Yeah, same. I've really appreciated the opportunity to have this conversation with Tom and with you. So thanks.
Well, I want to thank you both. We greatly appreciate your making the time for us and sharing your wisdom and your great knowledge of the Supreme Court and the cases and the upcoming term. And we wish you both lots of luck in your cases coming up this semester. And thank you for joining us.
Thanks so much.
Thanks for having us.
Wow, great.
A couple of housekeeping matters to go over. We have the next upcoming COSAL event is next Wednesday at 5 p.m. We have a fundraiser for Sarah Gideon. We've been working diligently to help elect Democratic senators that may align with our view of justice. We held a fundraiser earlier last year for Cal Cunningham, who is taking on Tom Tillis in North Carolina, and now Sarah Gideon, who is trying to unseat Susan Collins. The Washington Post says that this race is a toss-up. 538 said similarly, Gideon up by a point. So this is a very, very important election. It's a very winnable, hopefully, seat. And we hope that you would join us in doing a fundraiser on behalf of COSAL for them. I'm going to put in the chat a link to signing up for this, and I'm sure that Pam will again send out the invitation. I want to toss it over to Mark Suter, who's going to tell us a little bit about the upcoming events for our Young Lawyers Division.
Thanks so much, Rob. As Rob said, my name is Mark Suter. I'm an attorney at Berger Montague and one of the co-chairs of COSAL's Young Lawyers Division. Just wanted to take a few minutes today to share a bit about YLD, including several exciting updates and initiatives we have in the pipeline. First, a little about the group. COSAL YLD was started several years ago to engage COSAL members who are under 40 years old and who have been in practice for fewer than 10 years. YLD has traditionally organized in-person networking events, usually occurring around the annual AAI conferences in Washington. However, due to the coronavirus pandemic, in lieu of our usual in-person gathering, this year we are hosting a virtual wine tasting event. The event is actually taking place today at 5:30 p.m. directly following this talk, so in just a few short minutes. We are fortunate to have a small family winery from Sonoma County, J. Cage Cellars, deliver 3 bottles of wine to each participant's house, a Chardonnay, Pinot, and red blend, and we'll be having the husband and wife owners of the winery walk us through their winemaking process. In response to member comments and enthusiasm, we're also hoping to plan a similar virtual networking event for COSAL YLD members in the near future, partnering with one or more local breweries. COSAL YLD also has a number of members who are forming an antitrust book club. Members are currently considering which work among a growing body of modern literature on anti-monopolization to tackle first over a series of smaller substantive happy hours. And lastly, WildD is currently looking to mobilize our members to become increasingly engaged with COSAL's amicus and website committees, among others. In particular, we're looking for young attorneys who are interested in assisting with amicus brief writing opportunities and or drafting any educational content for COSAL's website. If you're interested, please contact me or check out your email for more. That's all we have going with COSAL WildD, but we're very excited for the upcoming year. And with that, I'll pass it back to Rob.
Thanks, Mark, and thank you to your co-chairs for the fabulous job that you're doing. And COSAL members, if there are lawyers under 40 at your firms, please encourage them to become active in the Young Lawyers Division. Given that A, we have so few opportunities to connect in person, and B, that we don't really do document production as we all grew up doing it anymore. There's not the same opportunity for young lawyers to get to know one another. And so this is an excellent opportunity for the growth of your attorneys. And so we hope they'll become involved. Pam, anything else that you would like to add?
No, I'll mute. No, I thought this was a fabulous, really fabulous presentation. So thanks to everybody who helped pull it together, particularly Bill Wickersham and Huntington Bank, as always, and Rose Colas, who always helps us with everything. So I was so thrilled to see so many people tuning in. That's great. Stay tuned, watch your emails. We do have the Sarah Gideon event next week. I'll be sending out something to remind everybody. And then we will have fall events coming up. They will be virtual. Maybe we'll follow the Young Lawyers lead and do some kind of wine tasting or something fun. But anyway, so watch the listserv, and thanks for tuning in.
Yes. Thank you, everyone. Appreciate your joining us today, and we'll see you all soon.
Take care.
Be well.